Subsection 100. Schedule means a schedule appended to this Act. Subsection 101. Securities shall have the same meaning as assigned to in the Class H of the section of the Securities Contract Regulation Act to 1956. The subsection 102. Services means anything other than goods, money, and securities, but includes activities relating to use of money or its conversion by cash or any other mode from one form currency or denomination to another form currency or denomination for which a separate consideration is charged. Explanation: for the removal of doubt, it is hereby clarified that the expression service includes facilitating or arranging transactions in securities. Subsection 102A. Specified auctionable claim means actionable claims involved or in by way of betting, casino, gambling, horse racing, lottery, or online money gaming. Subsection 103. State includes union territory with legislature. Subsection 104. State tax means the tax levied under the State Goods and Service Tax Act. Subsection 105. Supplier in relation to any goods or services or both shall mean the person supplying the said goods or services or both, and shall include an agent acting as such on behalf of such supplier in relation to the goods or services or both supplied, provided that a person who organize or arrange directly or indirectly supply of specified actionable claim, including a person who owns, operates, or manages digital or electronic platform for such supply, shall be deemed to be a supplier of such actionable claim, whether such actionable claims are supplied by him or through him, and whether the consideration in money or money's worth, including virtual digital assets, for supply of such actionable claim is paid or conveyed to him or through him or placed at his disposal in any manner, and all the provisions of this act shall apply to such supplier of the specified actionable claim as if he is the supplier liable to pay the tax in relation to the supply of such actionable claim. Subsection 106. Tax period means the period for which return is required to be furnished. Subsection 107. Taxable person means a person who is registered or liable to be registered under the section 22 or 24. Subsection 108. Taxable supply means a supply of goods or services or both which is leviable to tax under this Act. Subsection 109. Taxable territory means the territory to which the provision of this Act applies. Subsection 110. Telecommunication service means service of any description, including electronic mail, voice mail, data services, audio text service, video text service, radio and cellular mobile phone service which is made available to user by means of any transmission or reception of signals, writing, image and sounds or intelligence of any nature by wire, radio, visual or other electromagnetic means. Subsection level 100 level. The State Goods and Service Tax Act means respective State Goods and Service Tax Act 2017. 112 subsection. Turnover in the state or turnover in union territory means the aggregate value of all taxable supplies excluding the value of inward supplies on which the tax is payable by the person on reverse charge basis and exempt supplies made within a state or union territory by a taxable person, export of goods or services or both, and interstate supplies of goods or services or both made from the state or union territory by said taxable person but excludes the central 113 usual place of residence means in case of individual the place where he ordinarily resides. In other cases, the place where the person is incorporated or otherwise legally constituted. Subsection 114 Union Territory means the territory of Andaman and Nicobar Island, Lakshadweep, Dadar and Naga Haveli, and Daman and Diu, Ladakh, Chandigarh, and other territories. For the purpose of this Act, each of the territories specified in the subsection subclass A to F shall be considered to be a separate union territory. Subsection 115 Union Territory Tax means the Union Territory Goods and Service Tax levied and Union Territory Goods and Service Tax Act. Subsection 116 Union Territory Goods and Service Tax Act means Union Territory Goods and Service Tax Act 2017. Subsection 117 Valid return means the return furnished under the subsection 1 of the section 39 on which the self-assessed union tax has been paid in full. Subsection 117A Virtual digital assets shall have the same meaning as assigned to it in the class 47A of the subsection section 2 of the Income Tax Act 1961. Subsection 118 Voucher means an instrument where there is an obligation to accept it as a consideration or part consideration for supply of goods or services or both, and where the goods or services are both to be supplied or the identities of the potential suppliers are either indicated on the instrument itself or in related documentation, including the terms and conditions of the use of such instrument. Subsection 119 Work contract means a contract for building, construction, fabrication, completion, erection, installation, fitting out, improvement, modification, repairs, maintenance, renovation, alteration, or commissioning of any immovable property, wherein the transfer of property in the goods, whether as the goods or in some other form, is involved in the execution of such contract. Subsection 120 Words and expressions used and not defined in this Act but defined in the Integrated Goods and Service Tax Act, the Union Territory Goods and Service Tax Act, and the Goods and Service Tax Composition to the States Act shall have the same meaning as assigned to them in those acts. Subsection 121 Any reference in this Act to law which is not in force in the state of Jammu and Kashmir shall, in relation to that state, be considered as a reference to the corresponding law, if any, in the force in that state. So now we have understood the section 2, which is under preliminary, the definition. Now we shall understand the administration. The second chapter is administration. Here we have section 3 to 6. Officers under this act. Officers under this act, the government shall by notification appoint the following class of officers for the purpose of this act, namely the principal chief commissioner of central tax or the principal director general of the central tax, the chief commissioner of central tax or the director general of the central tax, the principal commissioner of the central tax or the principal additional directors general of the central tax, the commissioner of the central tax or the additional Director General of the Central Tax, Additional Commissioner of the Central Tax or the Additional Director of the Central Tax, Joint Commissioner of the Central Tax or the Joint Director of the Central Tax, Deputy Commissioner of the Central Tax or Deputy Director of the Central Tax, Assistant Commissioner of the Central Tax or Assistant Director of the Central Tax, and any other class of officers as it may deem fit, provided that the officer appointed under the Central Excise Act 1944 shall be deemed to be the officers appointed under this provision of this Act. Appointment of officers, Section 4, Subsection 1. The board may, in addition to the officers as may be notified by the government under the Section 3, appoint such a person as it may think fit to be the officers under this Act. Section 4, Subsection 2. Without prejudice to the provisions of the Subsection 1, the Board may, by the order, authorize any officer referred to in Class A to H of the Section 3 to appoint the officers for the Central Tax below the rank of the Assistant Commissioner of the Central Tax for the administration of this Act. Power Power of the officers. The powers of officers, Section 5 defines the power of the officer. Section 5, subsection 1, subject to such conditions and limitations as board may impose, an officer of the Central Tax may exercise the powers and discharge the duties confirmed or imposed on him under this Act. Section 5, subsection 2, an officer of the Central Tax may exercise the powers and discharge the duties confirmed or imposed under this Act on any other officer of the Central Tax who is subordinate to him. Subsection 3. The Commissioner may, subject to such conditions and limitations as may be specified in this behalf by him, delegate his power to any other officer who is subordinate to him. Subsection 4. Notwithstanding anything contained in this Act, in this section, an appellant authority shall not exercise the powers and discharge the duties confirmed or imposed on any other officer of this Central Tax. Authorization of officers of the state or union territory tax as a proper officer in certain circumstances. Section 6, subsection 1. Without prejudice to the provision of this Act, the officer appointed under the State Goods and Service Tax Act or Union Territory Goods and Service Tax Act are authorized to be the proper officer for the purpose of this Act, subject to such conditions as the government shall, on the recommendation of the Council, by notification specify. Subsection 2. Subject to the conditions specified in the notification issued under the subsection 1, where any proper officer issues an order under this Act, he shall also issue an order under the State and Goods and Service Tax Act or Union Territory Goods and Service Tax Act as authorized by the State Goods and Service Tax Act or Union Territory Goods and Service Tax Act as the case may be, under the intimation to the judicial officers of the state tax or the Union Territory tax, where a proper officer under the State Goods and Service Tax Act or the Union Territory Goods and Service Tax Act has initiated any proceedings on the subject matter, no proceedings shall be initiated by the proper officer under this Act on the same subject matter. The subsection 3. Any proceedings for rectification, appeal, and revision, wherever applicable, of any order passed by an officer appointed under this Act shall not lie before an officer appointed under the Goods and Service Tax Act or the Union Territory Goods and Service Tax Act.